All right. Good evening, everyone. Hi, my name is Ben Mirza, and let's get started here. I'm going to turn on the screen. Screen two, share. There we go. Can everybody see how experienced physicians protect their assets title?
Yep, we can see it, Ben.
Perfect. Okay. So, so today our topic is really asset protection. Let me just start off with like a quick 10-second summary about who I am and what I've done in the past. I'm an attorney. I've been practicing since 2001. I've got multiple degrees, which kind of like stack themselves on top of each other. So like anywhere from accounting to the JD of law to the LLM of taxation, which is where I picked up my background on trusts and how trusts are put together, and then also my master's of public health, which kind of helps me figure out the strategy of where healthcare is going. So those degrees stacked together, that's how I pretty much that's a skill set I bring, and that's how I work with my clients. And over the years, thank God, I've actually been fortunate to represent some really great companies and firms, and also that's in a nutshell. So just so you know, this webinar is being recorded, and it's being recorded for educational purposes. What is contained in this webinar should not be considered legal advice, and I actually have no financial interest to be gained with or with in terms of anything that relates to patients here in this sort of a situation. So. Now, today we're going to be talking about how experienced physicians protect their assets, and we're going to kind of focus a little bit on patients, spouses, and people with kids in their cars, right? So, if you look at physicians and what exposes them to certain liability, like legal liability, it's usually these three sources. It's patient, spouse, kids, and their cars. So, so we're going to talk about that today. Here is the outline as to what is ahead of us tonight. In the beginning, we're going to start off real nice and slow, where we're going to talk about necessity of asset protection and what is it really, and then we're going to quickly jump into asset protection planning techniques, and we're going to walk you through basically three major groups of asset protection planning techniques. One is the legal safe harbors that are out there and available for you. Number two, we're going to talk about corporations and how to use corporations in an intelligent way where it's strategic and it makes sense for you. And number three, we're going to talk about trusts, and then we're going to put it all together into almost like a gradient form as to when is the right tool for the right level appropriate. And then last but not least, we will have a brief conversation whether to insure or to self-insure, meaning or not buy insurance, where you actually guarantee the funds as a physician that are available and should a lawsuit ensue. So we'll have some discussion on that as well. So throughout this webinar, I encourage you to ask questions. However, if you have a personal sort of a question, just do remember that it is being recorded, and in the end, we will stop the recording so you can ask your personal question afterwards, and maybe the rest of the audience can then listen into that versus it going on a recording on YouTube or something. So, when it comes to asset protection, not all things are equal. So the point of this slide is twig houses versus brick houses, and bikes versus cars. For different people, certain houses work. Meaning, you can have a twig house or you can have a mansion, right? Or you can have a bike, and that's plenty for you to commute on. Or you can have a super fancy car. And an asset protection kind of works that way. So, easily put or summarily put, asset protection, you really have to kind of divide up whether the individual is a low or a normal net worth individual or a high net worth individual. And they use different tools. When you're a normal net worth individual and when you're a high net worth individual, those tools are a little different. Now they're layered one on top of the other, but nonetheless they will be different. Now, it's also going to depend on the risk factors that the individual is seeing. and the cost versus the benefit of what they're trying to do. So, meaning if you are a person with like a $2 million net worth versus a $5 million net worth, that's already a different bracket in my mind. And if you go from 5 million to 10 million, again, I think that's another bracket jump. And once you, I think, exceed like a $50 million mark as your net worth, I think you're in a totally different league altogether. And so your planning has to be very different on that. And later on in this seminar, we're going to be talking a little bit about that and the kinds of tools you can use. So the way majority of my asset protection planning works is I'm generally looking at a Camry. I'm not looking at a Mercedes. I'm not looking at a bike. I'm generally looking at people who have some robust income and they have something to protect. And what I mean by that is not only do they have current assets, but they also have a future income stream that they also want to protect. So they will go into asset protection planning. So what is asset protection and why is it necessary? So what is asset protection? It's really the adoption of strategies to guard one's wealth. Um, it, it is not the concealment or hiding of assets. It is not a contempt. It's not it's some sort of a fraudulent transfer or tax evasion or even filing of bankruptcy. So we're not going to be talking about any of those sorts of issues tonight. All we're going to talk about is adopting of strategies that'll protect your wealth. And do remember, your license is an asset. The reason why you're here today is probably because you're a physician and probably because your license is an asset. And the whole world sees it that way, not just you. Whereas in our world, we may see each other as equals and we all kind of like look at each other and go, hey, a two, three, $400,000 salary is not that much, but to most people, even a $200,000 salary is quite significant. So you've got to approach asset protection planning a little differently. And I think because you are different than a normal person. Now, before we go too much far down, I do want to warn you about this one particular statute, and I just want to point it out to you. Is Florida Statute 726.105 and .106. It's the Fraudulent Transfers Act, which basically says you cannot try to conceal an asset or try to evade taxes or file bankruptcies just for the mere purpose of avoiding debt or creditors. And Florida actually has a 4-year look back, a 4-year statute of limitation, and it begins from, for example, from this day forward. But as soon as the claimant finds out about it, they still have 1 year to bring the lawsuit to fruition. So there is a statute of limitations there. Really, the 4-year one is the one you got to keep your eye on. You got to make sure that everything is in your rear view mirror that you've done, and everything that you did is not considered a fraudulent transfer, and it will go into your history books by at least 4 years. So that's really what we're looking for. That's why asset protection kind of starts earlier on. You got to really do it like 4 years in advance of whatever you might be anticipating. So like, for example, if you're looking to take on some riskier projects in the next few years, you should probably try to plan it so that, those don't become a real liability for at least the first 4 years that you did your asset planning. So what are some of the sources of liability? So why is asset protection necessary? It's really because we go through these situations where we have certain adversaries or certain things that work against us. A spouse or a divorce could be a very likely scenario. As you know, divorce rate in the country is 50%. So that's a possibility. Vehicles is another source of liability. If you or a family member who is driving your car happens to hit somebody else and they happen to find out that you happen to be a high net worth individual, they will treat that accident very differently than knowing that you are a low net worth individual. So keep that in mind. Now, you could have visitors that come to your real estate or your property and there's a slip and fall, and they might see that as an opportunity. Like, for example, what I can tell you is I once hired a contractor, a complete legit contractor. However, the contractor did something like this. they he went to some sort of like a Home Depot line, picked up a person from there to come and work at my house. And when he showed up with three people to work at the house. And as one of the individuals was there, he was kind of swaying back and forth. And I'm thinking, why is this guy swaying and why is he on my property? So the first thing I did is I asked my contractor, number one, where did you get these people from? Number two, can you get rid of the guy that's swaying? Because there was definitely something not right about that. And that's what I mean. If you invite people onto your property, you don't want to get held liable for it. And I keep an eye on just about anybody who does come onto the property, making sure that they're okay to be there and that they're not looking for opportunities. Now, the other way that you could have liability pop up is if you're involved in certain business organizations. If you happen to be on a board of some sort of an organization, sometimes the other shareholders or the members might accuse you of things or taking something, or you could have a business misunderstanding, and that also opens you up to liability issues because they might say you've done something improper. Now, when it comes to your professional license, your patients or your clients are can suffer a loss from something gone awry. Also, there's regulatory compliance issues that you've got to worry about. There's data security stuff, and if you're really wondering whether you've gotten the right consents and waivers from your patients, you may want to take a look at your release and waiver forms that are being filled out in your office, because that may be a way to kind of start your asset protection planning. Now, you may want to ask for these consents and releases at the time of entry or intake. And remember, at times before performing high procedure, you may want to reiterate that, as you may have seen. And sometimes when you or a patient goes into a hospital, they will be given a form just before a procedure is going to be performed. And it's basically a regurgitation of the prior forms that they had. So that's really kind of like your sources of foreseeable liability. Now, there could be other sources, but I can't think of any off the top of my head like that easily. But you're welcome to put it into the chat group if if, um, if you want to share a unique situation. Now, so that was the part about what is asset protection and what are the sources of liability. Now we're going to start talking about legal asset protection techniques. So the first legal asset protection technique I want to cover, which is really a no-brainer, but a lot of people overlook it, is the use of existing statutory safe harbors. Now, we're going to be talking about Florida safe harbors. However, a lot of other states have similar laws. For example, the Florida homestead. The Florida homestead actually allows for half an acre within a municipality to be homesteaded, but you can only have one property in the whole entire state that is homesteaded. Or if you happen to live outside of a municipality, you could have 160 contiguous acres. Contiguous meaning they all have to be connected somehow. They could be in a U shape, but they have to be connected. They just can't be like, an eye with a dot on top of it. It just has to be contiguous. There's got to be no separation. So, so a lot of people, what they will do is, and you may have heard this before, is that a lot of wealthier folks will move to Florida specifically for the homestead laws that we have here. And what they'll do is they will pay off their house as quickly as they can, so their house becomes their nest egg, and because it's protected from creditor attack. Now, typically, a homestead really is only liable to two types of creditors. One is an actual mortgage that's on the property, and the other one might be a association, whether it's a condominium or a homeowners association. They are open. Homestead properties are open to that attack from a creditor. Now, the other thing to keep in mind is life insurance policies. You may want to, life insurance policies is another protected way of preserving your assets, where you can actually move your wealth into a life insurance policy. And one of the individuals that happens to be here tonight, his name is Howard Wolkowitz. He's actually quite adept at those sorts of strategies. And Howard, if you wouldn't mind just putting your phone number and name into the chat box in case if anybody wants to contact you regarding the life insurance policy plans that you might offer. The other thing to keep in mind is that retirement plans are also protected. So if you happen to have your own business or a small business, you may want to sock away a lot of money. I mean, you can actually put away, there's certain percentages that apply. So like, for example, I was looking at it recently. I think if you're over 50 years old, you can put away up to like 25% of your income into a retirement plan. And I was just looking at this because I was trying to figure out some stuff for my own self. So, but these are basically three things that we just talked about here, and that's under statute. So like the homestead, the life insurance policy, and retirement plans. Those are protected from creditors. But then what happens to all the other stuff, like the other investments, like your ownership of business, your bank accounts, the other real estate you may own, cars, stocks, bonds, jewelry, some sort of a collection you might have, or even your safe deposit box, that is all open to attack from creditors, meaning so if you owe somebody money, they can actually come after all of your unprotected assets. Now, the next thing that I want to talk about is corporations. How are corporations set up? How are they used? And what do you need to consider before you use a corporation? I'm not going to walk you through the rudimentary examples of should you do an LLC or a subchapter S or whatever. We're not going to talk about those sorts of legal technicalities because I think you've got to take a much more practical approach to this. And this is what I look for. First of all, you've got to file articles of incorporation. They're really easy to do. They're super easy to file. All you do is go to sunbiz.org. But when you go there in the state of Florida, do you want it to be the state of Florida? You may have heard of people that actually incorporate in other states. Some people incorporate in Delaware. Some people incorporate in Nevada. Other people incorporate even in like Alaska or Arizona. And I've seen and heard arguments for incorporating in other states. I'm not a big proponent of it. I prefer Florida just because Florida is controllable for me. It's where I am. It's where I know what the laws are. It's where I can get to court. It's where, everything, 90% of what I do is within the state of Florida. So I want the state jurisdiction of Florida. But there are some people out there that'll tell you you should go to other states and you can actually, it's beneficial to you. So if they are telling you that, then you got to really think about, well, number one, are you okay with that? Are you comfortable with that? Are you willing to put up the additional cost in filing in other states? That sort of stuff. And then the other thing you got to consider is every time you create a corporation, it creates a whole other set of paperwork and accounting that you've got to keep up with. If you don't keep up with that paperwork and the accounting, creating a corporation did you no good. So once you file a corporation, you've got to really follow through over the years and stick with it as a vehicle for asset protection. So that's the first thing when it comes to actually corporations. You got to think about the practical side of it, and all you got to do is file the articles of incorporation at sunbiz.org, and you're pretty much done. The next thing you have to think about is getting an operating agreement or bylaws put together. So what that basically, if you're a sole shareholder of an organization, or maybe if it's just you and your spouse, or you and a sibling, and you guys don't really care back and forth as to who's got what percentage, or it's well understood, and you trust them wholeheartedly, that's one thing. But if you are actually going into business with another partner that is not that closely related to you and you don't know them extremely well, I suggest that you actually put together some pretty smart operating agreements or bylaws, and you've got to look at it very differently because to every business relationship that you enter into, there will be an exit one day. So you've got to know what the exit strategy is. The other thing some of you may have seen is you may be a part of an organization where there are different classes of stock. The classes of stock can be named anything. You could call it Class A, Class B, Class C. You could call it Class Alpha, Beta, Kappa, Gamma, whatever you want to name it, you can name it. And then, however, those classes of stock are defined in the actual operating agreement is what the power will be behind that stock. So normally, what I've outlined here is basically four different types of stock that's available out there. Number one, there's like a normal investor who has a voting share. Then there are investors, like a normal investor, that has non-voting shares. So, like for example, if you happen to get into a healthcare business and you are bringing on investors, you may not want your non-healthcare investors to have a vote because how much do they really know about this healthcare business? Uh, and also, I'll tell you, you may not want anybody to have a vote other than yourself. If somebody wants to invest in your business, they can. They can get a proportionate share, but you may not want them to at all have a voice or a vote because you need to do things the way you need to do them to get things done. And I can completely see an argument for that. Conversely, anybody who comes in is going to want to vote. So you're going to have to figure out how to balance that out if you decide on using multiple classes of stock. Now I've gone on to talk about Class E and Class F is what I is how I normally refer to them in my agreements. But you could totally flip this. You could make the non-voting, non-earning stock your Class A stock, and label it the other way around. So, and sometimes companies do that. They will give the weakest stock Class A classification because it sounds stronger than Class D, so they'll do that. The other thing is sometimes there is also like what's called a Class F stock that I've used before, and it's the founder's stock where they get an overriding power no matter who the board is, and they cannot be kicked out of that corporation without their permission, and that corporation cannot be sold without their permission. So these are the multiple classes of stock. You got to think about them when you're setting up these corporations. Who's going to own it? Who's going to have a voting voice? Who's going to just be a simple investor? And then you got to figure out if the investor is truly investing or is the investor just lending, right? Because sometimes the investors will get shares for lending. Sometimes the investors will actually contribute hard dollars. Now, there is also what's called sweat equity contribution. Sweat equity generally means the person who usually doesn't have the money, but they have the knowledge and the willpower, yeah, and the time to work in the business. So they get a certain percentage. So what you have to do there is that you can create that sort of a relationship, but you have to assess the fair market value for that sweat equity person. What would that be, and how does that compare to the cash contributor? So, like for example, if you happen to be a really good, I don't know, stitcher on of like shoes and pants, what is the fair market value of a really great stitcher? What is the value of a really great manager of stitchers if the person is such? That's somebody who stitches. However, now you turn around and you compare that to a physician who starts up and puts in their sweat equity into starting up a company. So what's the value of a physician dedicating 10 hours of time versus a shoe cobbler putting in 10 hours of their time? So you got to really compare what the sweat equity is worth and how much time are they likely to put in. And you got to take a look at what level are they serving? Are they just literally being a technician or are they being a manager? And that will require a different level of sweat equity earnouts. So probably the most important thing that you have in your operating agreement is your exit clause. And you've got to figure out how that's going to work. So let me just walk you through a couple of different situations. Number one, sometimes if you actually own a corporation and an investor comes in, you may want the right to buy them out because you might decide after a while that, hey, I don't need them anymore. Maybe I don't want them around. Maybe they're a problem for the way you operate. Maybe there's other issues that are going on that you just want them out of your way. So you might just want to buy them out. So you want to make sure that your exit strategy has a buyout provision for that person. Now, what if they happen to come in as an employee and maybe then they decide to leave? What are you going to do about that? Are you going to give them employee shares or phantom shares so they don't actually have real equity, but they kind of mimic the equity of the company and maybe there's some kind of profit sharing that they get? What's going to happen if there is a buyer that knocks on your door and says, "Hey, I want to buy your company." Who's going to have the rights, the say so, to sell that company? Um, so all of these things matter. I've also recently been involved in some pretty good litigation stuff involving partnerships, and partnerships are kind of strange because partnerships have their issues. Partners will get along really well at one level, and at other level, there's a rub. And depending on how bad the rub is, it can really work against them, right? So it can really work against their relationship. So you have to figure out, like, is are the partners breaking up because one person is getting pushed out, and is that a value of x plus 10, or or are they wanting to leave on their own, which might be a value of x minus 10? So you could give it a positive value or a negative value depending on who's wanting to leave. Now what if but don't be naive about it. What you need to kind of also understand is that people will force situations upon the other to make sure that things look like they're getting pushed out so they get a higher premium, and vice versa. So these things happen. You just got to be aware of them, but you got to approach it with like a real skeptical sort of an eye and be really, really tight about it and be very, very specific about what you want. Now, you may have heard that there are some pretty big size equity groups out there that are inviting physicians in, and they're saying, "Hey, come on in. We're going to give you shares, and you're going to get like 5,000, 10,000, 50,000 shares." But what you really have to figure out under that sort of a situation is, what percentage of shares am I really getting? 10,000 shares as compared to how many of total shares, right? So that's really what you have to like look at, is what percentage are you exactly getting? A lot of these private equity companies will not disclose to you what their total outstanding shares are. The other thing that you also want to make sure is, because you are a physician, is that none of the other partners are Medicare excluded. Because if one partner is Medicare excluded, that means the whole entity is Medicare excluded. So you got to be really, really careful as to who you actually go in bed with when it comes to these. Now, you may have heard of the word corporate veil. A corporate veil is really a legal fiction, in the sense that it's a fiction created through legal statutes. So as soon as you create a company, in our society, we've come to this understanding that we're going to treat that company as if it's its own walking, talking individual. However, it's operated by individuals. So, in order to maintain that company as being independent of of the individual, or the individuals operating it, you've got to make sure that you keep up with the bank accounts, the separation of money, the ironing out of contracts, that the contracts are laid out nice and firmly, so that the intentions of the individuals doesn't get confused with the company. Because otherwise, if, let's say, you have a company and you start to use it for your personal entertainment, for your personal stuff, for your personal cars, for your personal vacation, for your personal things, then it starts to look like you and the company are one and the same. And if that starts to happen, you got to really step back and make sure that you justify the expenses that you are pushing through the company, and that it's not just, and that there's an actual basis for it, and they're not just willy-nilly sort of expenses. So they've got to have a business justification. Now, if you have more than one company, what you do is you can create intra-company contracts. And again, you're only going to set this up every now and then. You're not going to set it up like all the time, but you're going to put in writing as to company A and company B, and then you'll separate things, and you'll have an intra-company agreement where the money can flow from one to the other. And we'll talk about that in our next slide as to how the money flows from one to the other. Now, most of my better off physicians will generally incorporate it under a LLC and a PLLC. So the PLLC will hold all of the professionals, meaning the professional providers, right? So like the doctors, the nurses, anyone who's billing under Medicare, Medicaid, or the insurance companies is an employee of the PLLC. However, all the other folks will go into an LLC. It's much like having a LLC MSO versus a PLLC. If you have any questions, this is probably a good time to ask because this is a really key point. So if you separate the assets of having an LLC, that's essentially the management half of your company. Then you have the PLLC, which is merely a employment company. Okay, so what you're going to end up doing is running all of your patients through the PLLC, and you're going to pay the LLC for all of the staff, the equipment, the leasing, all those things that are paid for that are non-healthcare uh, uh, um, provider related. PLLCs are generally used by doctors, by lawyers, by accountants, engineers, mostly professionals. And that's when you form a PLLC. Now, the PLLC has the same benefit as an LLC, meaning that there is no personal liability on the individual. Now, keep in mind, there's also what's called a LLP. You can hold a limited liability partnership, which is almost 6 1/2 dozen. It's the same as a PLLC. There's no difference. But just stay away from a general partnership. If you are a part of a general partnership, that is highly antiquated. There better be a really good reason as to why you're in a general partnership, because in a general partnership means that you're not uh, 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 only getting the benefit, but you're also getting the liability of the corporation. So so the GPs stay away from them. That's why that is in red. Now, a lot of times my clients will ask me, "Hey, what's the difference between subchapter S and subchapter C?" Really, there's one key difference. There's a few small differences, and for the most part, they're irrelevant to 99.999% of the people. However, there's only one real difference, and even this difference is minor, which is as a subchapter S, it's got a limitation of 100 shareholders, and it's taxed at the individual shareholder level. So, meaning, for example, if you've got income of 100,000 versus 500,000, with respect to that subchapter S, that's the kind of taxes you're going to be paying as that subchapter S corporation um, uh, generates profit. However, under a subchapter C corporation, you get taxed twice. So just stay away again from subchapter C corporations. That is probably not your way to go. Nowadays, almost everybody that I incorporate gets incorporated under LLC, and and periodically we also set up a PLLC. Now, keep in mind, there is other name nomenclature out there, like you see at the bottom of the screen. You could have an Inc., a Co., like an incorporated or a company, right? So you can use those as well, but if you do that, then you got to pick the subchapter S election, and you got to do other formalities to it. But what you're going to end up doing is you're going to end up stacking and making sure that these corporations stand next to each other. And what you do is you take similarly situated assets and put them into similar sort of companies. And you take similarly situated liabilities and put them into similar companies. So what I mean by that is, for example, if you're holding a investment stock portfolio, you put it into a investment stock portfolio company. If you're holding real estate, you put it into a real estate company. Because you want to make sure that that's insulated. If a renter comes into a property and they happen to rent and they happen to have a slip and fall, they might decide to sue the company that owns that real estate. And if it does, what do you have to protect yourself against it? We're going to talk about how you can do that in just a minute. Now, going back to the other scenario where I mentioned if you have certain investment accounts, you want to make sure that those stay separated. Similarly, if you have a high liability company, if you know that a particular company has a potential high liability, what you want to do is you want to separate that from your good assets. So that's why I say separate your PLLC from your LLC to separate the profits. What you're going to do is the PLLC will pay out the salaries to all of your providers, meaning the doctors and nurses, but the LLC will get a management fee and pretty much everything else that goes with it that was generated out of the PLLC, and it gets pushed over to the LLC. Also, keep in mind you can layer and stack these companies on top of each other as holding companies and as lending companies, right? So For example, let's go back to the scenario where you own a piece of property under a company name. And if it's a fully paid off property, if somebody gets injured in that property, they've got the full entire gamut of what's owned in that real estate LLC to go after. So how do you hedge against it? You create another lending company that actually takes out a loan and it lends the money to the real estate LLC. So you're like, leverage to the hilt, and your other good company is the lending company, and that's the one that has the cash in it. So you want to make sure that you've got a nice relationship set up where anything that's paid off that has a pretty nice net worth, you want to leverage against it. You want to make sure that those assets are encumbered, that they are no longer open and free to attack. Because again, looking at that sort of a rental property situation, if that's a nice and free looking asset, people are going to go after it. So you've got to start separating things into buckets and start looking at them a little bit differently. You got to look at them in terms of assets, similarly situated assets going to different companies for that purpose company. So like real estate, like I said, would be in one, your investment accounts may be in another, and yet your other businesses that you might have, let's say you own a part of a gas station or a dealership or something like that, maybe you put that into a completely separate company. So I think I covered that. If anybody has any questions, this is probably a good time to ask them. Okay, I'm gonna move on to the next thing. So now let's talk about trusts. Trust is another tool used by usually the wealthier individuals will start to get into trusts. Everything starts off at the level of companies, and then it migrates towards trusts and companies together. And I promise you, I'll bring it all together in the end when I start hitting the last quarter of this presentation. So there are certain key things you need to understand about trusts. There are basically three types of parties to a trust. Every trust has a grantor, a trustee, and a beneficiary. A grantor is a person that puts in the money or puts in the value or puts in the asset into a trust. The trustee is the one that administers the trust, oversees the trust, files a paperwork for the trust, and is responsible for making the decisions in that trust. The beneficiary, the ultimate beneficiary, are the people who benefit from whatever is sitting in that trust. So like, for example, it could be a parent setting up a trust, and that trust has a trustee of perhaps one of the aunts and the uncles as a trustee, and the beneficiaries might be the children. However, you can have a trust that you yourself could be a beneficiary to, and if you yourself are a beneficiary to it, then it's no longer protected from creditors because you are the actual beneficiary of that trust. So if you're looking to separate your assets from you, so if you ever get sued, you have a layer of protection in the middle. What you really have to do is you have to make sure that you have a irrevocable trust, and that trust has somebody else as the ultimate beneficiary. Now, you could have trusts where you live off of them in the meantime while you're alive, but ultimately somebody else ends up with it. You could even put in things like what's called a poison pill into it, where the trust, essentially self destructs should someone come after it, and the assets completely move on to the beneficiary as soon as that trust comes under attack. So that's a way to make it implode, and you just move it right along. Any questions so far? Now, do remember, if you have a trust and you have a trustee over it, the trustee must be a stable individual. You cannot have somebody that's unstable, meaning several things. So how do I consider stability? Number one is obviously, is the person rational? Are they within their senses, or are they erratic? Or can you trust them, or can you not trust them? The other thing that you also want to consider, and a lot of people don't, they may have a perfectly good relative that they want to put in as a trustee, but there may be a creditor after them. So you want to keep those sorts of trustees at bay, and the trustees could come under attack. The beneficiaries could come under attack. So the beneficiaries are actually more susceptible to that sort of an attack. So, like for example, if you have an irrevocable trust and your child is a beneficiary to it, if your child does something wrong or borrowed money, um, and doesn't pay it back, that creditor essentially has rights to that trust, and they can go after the assets that are sitting in that trust. Now there's ways to protect against it, but again, nonetheless, because your child happens to be a beneficiary to that trust, the creditors can go after it. Now every year you will have extra paperwork and you will have extra accounting to do, and you've got to make sure that your accountant takes that, puts that into their annual filing, because each trust has to also have an EIN number, which is an employer identification. So you should try to have the trust in a place as soon as you believe you are at a stage to create one. So it needs time to kind of ripen. You know how we were talking earlier about the 4-year rule? Well, the earlier you get it started, the quicker it ripens and it kind of goes back in time and it's less open to attack. Also keep in mind that there are many different kinds of trusts. Easily, there's well over a dozen. Um, but here's just a few of them uh, that I found and saw and have seen over the years. But the ones that I pretty much use is generally either a land trust, an asset protection trust, or a special needs trust. Now, an asset protection trust kind of makes sense for what it is. You're putting away assets that are generating income, and you just want to keep them protected. So, you put them into an asset protection trust. You could call it whatever you want to call that trust. You could give your trust a name. Like, for example, one of the trusts that I used to have under my name, I used to call it 6100 Land Trust. It doesn't mean anything to anybody else but me. So I just knew that was the street number of where my land trust was. The other thing you may want to take a look at is certain individuals have needs, or their family members have needs. You may have somebody who's disabled in the family that needs certain money put away from them. So you can actually allocate certain monies under a special needs trust, get a special sort of provisions put in there, because the ultimate beneficiary cannot make decisions on their own. So a special needs trust is going to be managed a little differently than all the other trusts. And you got to just make sure that you take care of that, because it's an obligation you may have that you feel that you got to take care of with your family. All right. So what assets do trusts typically hold? Well, like I mentioned earlier, here's just an example. There's a family trust. It has a starting date of whenever it starts, and it's got a tax ID number. And the tax ID number can either be the grantor's number, or you can actually create a specific trust EIN number as well. So this is when you get your tax consultants talking to your attorneys, and that's when we figure out what's going to get a tax ID and what's not. Then there's also, you can have hold in it household accounts, household goods, personal property, contingent beneficiary, retirement accounts. Like, you could have retirement accounts being held in there. You could have business interests being held in your family trust. You could have other personal residences, your residence. You could stack it in with just about anything you want: cars, goods, jewelry, gold, bullion, stock. Whatever you can think of, you can actually put into a trust. If it's an asset, you can put it into a trust. But a trust, remember, keep in mind, it's intended to generally hold assets. It doesn't, and it's supposed to ward off creditors. So usually your better things move into a trust, as opposed to like your high liability businesses. You would not really put them into a trust. You kind of keep them separated. All right, moving right along. So the next thing is, how do high net worth versus low net worth individuals use the tools that we just talked about? So what I'm going to walk you through is two slides. The first slide is going to give you the 5 easy tools, which everybody should be using. And the second set is going to be the more complex tools, which some of you will want to start using. So here it goes. So you notice I struck the part about low net worth. I just called it normal net worth because most of us only have money that's considered normal sort of net worth. So if you're under a $5 million mark and that's your net worth, you're pretty much of a normal person, and you don't have a whole lot to worry about. But you may want to start thinking about it once you hit a couple of $1 million worth of net worth. So here are some basic, easy tools to use. Number one, the Florida homestead, like we talked about. Putting your money into retirement accounts and life insurance policies. You can talk to Howard Wolkowitz on that one. And then also keep in mind there is what's called a spousal privilege. That there's something that's called tenants by the entirety. You may have heard of this, but the tenants by the entirety is a very, very key provision. If there is a spouse, there's a husband and a wife, or two people that are married in law, they can actually hold a account as tenants by the entirety, and it can only be done with spouses. So what that basically means is let's taking a traditional example into account, a husband and a wife, once they get married and they, let's say, create a bank account under their joint name as tenants by the entirety, that's considered a separate individual. So if the wife's creditors come after her, they can't go after that account. If the husband's creditors go after him, they can't go after that joint account, because the joint account is considered yet a third entity and a third individual, and it's almost treated like if it's separate and apart from those two, husband and wife. So that's a really easy way to protect your bank accounts. Some of your, investment accounts might be a good way to do that. Even some of your real estate, to a certain extent, you could do that. And then if you're not married and you happen to have a really good family member or a really good partner or something to that effect, what you do is you can create what's called joint tenants with the rights of survivorship. Now, generally, when that's split up, you're deemed to only own 50% of it. But nonetheless, if you pass away, the other person gets it without having to go through probate because you put in rights of survivorship. Now, the downside to all of these joint naming convention is either party can trigger the sale of an asset. And if you are just tenants in common, the property is then vulnerable to debt. And if you happen to have joint debts, if you own good assets, that joint debt that you own can be applied against your good assets that you own jointly. So if the naming convention is the same on the debt as it is on the asset, the creditor can come after the asset. Now, do keep in mind that IRS liens can attach to both types of naming conventions. It doesn't matter if you're tenants by the entirety or if you're joint tenants. When property passes intestate, that means that it's passing without a will. So it generally means that you're going to have to get if you have rights of survivorship, it's going to pass right along to the next individual, and you don't even have to mention that particular property in your will for it to move along to the surviving individual. The fifth thing that you can use is actually insurance to protect yourself. We all have auto insurance. A lot of us have professional liability insurance, but there's also what's called excess liability insurance. You may want to consider excess liability. So, like for example, if you have if you get into a car accident and let's say that there is damage that's above your insurance limit, then what you do is you would trigger your excess liability insurance coverage. Now, excess liability is fairly cheap as compared to even car insurance or professional liability insurance. It's usually within $1,000 for a few $1,000,000 worth of coverage. Pretty cheap, pretty easy to get. Excess liability is a great insurance to carry. Now, some of you that are on here, you may be considering going bare, meaning without insurance, without professional liability insurance, you can save thousands of dollars a year, but you have to really weigh that against the downside of what can happen. And we're going to talk about that a little bit in just a few minutes. Well, actually, we don't have a whole lot of time left, so it's already 7:25. So let's go into the 5 complex tools. A lot of times you may want to consider using a land trust. You may want to consider hiding a name. You can actually hide your name even in the division of corporations. You can have a assigned individual. For example, your accountant be the custodian of the record for that corporation. You can have your attorney do the same. Um, so yeah, there's ways to actually hide your name through land trusts, through corporations. And you may also want to consider prenuptials or postnuptial agreements. Now, prenuptials and postnuptial agreements, really, I advise for them if you think you're going to be a lopsided couple. If one person has a high income potential and the other one doesn't, that might be a time to consider a prenup. If one person has a high inheritance potential and the other one does not, that might be a time to consider a prenup. If one person is going to make a killing at something and the other person is going to drag them down, sorry to put it that way, but you may want to consider getting a prenup. Now, what you ultimately end up doing is you'll use all of these tools to layer the assets and the debts, and you'll create debts from one company to another that help you protect those assets. The other things to keep in mind is you can also add what's called a poison pill, which is certain provisions you can put in there where you basically say that if this particular company comes under attack, the shareholder automatically loses their equity rights to the company or their voting power to the company. However you want to frame it, you can frame certain poison pills inside the operating agreement. I've done that before on rare occasions, but we do. You can layer the trusts within a trust. So, and the other thing you can also do is you can move assets to a different country. I rarely ever get that request from any of my clients. I think you got to have gobs of money in order to get to that level. But if you've got like, a few $1,000,000 worth of net worth, then you're probably in on this complex tool slide. So make sure that you use all of these things listed on the first slide in the simple tools, and then you go on to the more complex tools. Now, here, I'm going to be sending you a copy of this presentation afterwards. Here is an example of how you can set up trusts and companies and have them all interact together. And you can create layers. The more layers you create, the more distance you become from the liability. And the harder it is to pierce that veil to get through to all of your good assets. So that's really the idea behind asset protection techniques. Now, most reasonably well-off individuals, meaning not rich, but reasonably okay, will use like a 3-layer approach. They will have a company, they'll have a trust, and they'll use some combination thereof in between to create their asset protection plan. However, you can make that very, very complex, and it's got no limits to it. But like I said, I work on Camrys. I don't work on Mercedes, and I don't work on 2-wheel bicycles. What I do is I build Camrys, and that's in my law practice. So I help people out with their normal stuff, normal things, at like a normal level. So going without insurance, right for you. And it might be a thought that you were thinking about. So I kind of wanted to bring you up to speed as to what the legislature has and the things you may want to consider. So, as you know, Florida has a tort reform act, right? And there was recently in March 2023, there was a House Bill 837 that was passed that actually helped us with that. And it's a statute of limitations where the statute of limitations for negligence was shortened from 4 years down to 2 years, meaning that the individual who was harmed in a medical malpractice situation, they have 2 years from the date of knowledge that something occurred to bring that lawsuit. It's no longer 4 years. So that's been modified to the benefit of the insurance companies or the physicians, depending on how you look at it. So also keep in mind, lobbying for the physicians is important. That's why I put the flag from Tallahassee up there. That's the capital. I know a lot of physicians steer clear of anything having to do with politics or anything having to do with governance and administration. But I encourage you, please, please, please join your local association like the Broward County Medical Association or the Dade County Medical Association. Wherever you live or wherever you work, please join your local medical association. Become a part of it, become active, because you physicians need each other. And I can't believe how your rights are being hampered, and there's not enough angry physicians out there that aren't taking that on as a fight. So back to Florida tort reform, there is a limitation as to injury. There, the non-economic damages, meaning anything having to do with not like emotional distress or other things that would be um, would be not an exact result of the injury itself. There's a limitation of $500,000, and in catastrophic cases, there is a limitation of $1 million. But do keep in mind if that actual economic damages have no limits. So if there happens to be a patient that suffers a loss of income, that could go against you. That is an economic damage. If they if they have medical bills that are exorbitant, that have stacked up because there was some sort of a malpractice issue, those medical bills could be part of the economic damages. Now, if there is ongoing care that person needs because of something went wrong and they can't, let's say, I don't know, walk anymore and they need some kind of therapy, that can add up. So if you see over here on the right, this example in blue, they're just meant to be examples, and just so you can understand, like, wow, these actual economic damages can really stack up pretty quickly, right? But for the actual injury itself, it is limited to 500,000 and $1 million. But it's all of these other economic damages is, I think, where your biggest liability is as a practitioner. So again, I asked the question: do you insure or do you self-insure? Meaning, do you go bare? The state statutes require that if you are not practicing inside a hospital, that you have $100,000, $300,000 worth of coverage. But if you are inside a hospital, that you have $250,000, $750,000 worth of coverage. I think everybody's familiar with that. If you want me to slow down, I can. But right now, I think we're running close to out of time. So, but going bare, if you go self-insured, all it requires is really an attestation that basically says, "Hey, I have a net worth of that exceeds the statutory requirement." And I think all you have to show is that you have a net worth greater than $250,000 on that attest. It's been a while since I've seen that attestation form, but I think it's about $250,000 is all you have to attest to. It's not that hard to actually comply with, but that's what you have to attest to. And now, from what I understand, the state of Florida is asking for some level of proof that you do have that kind of equity somewhere in one of your assets. So the other thing that you would need to do is, if you decide to go bare, is you will need to put a sign in your lobby. It has to be prominent, and it has to show that you do not carry insurance. The other thing that you need to do is you need to have your patients acknowledge that you do not carry any insurance. Now, just so you know, statistically, and I've heard this from other people, including insurance agents, they say that physicians who are not insured get sued less often. Now, if it's me, and I didn't have a whole lot of net worth, let's say I only had a net worth of 500 or $1 million, I don't know, maybe maybe you want to protect that. Maybe you don't want to necessarily protect that. But once you hit $20 million, you've got a lot to protect, right? So I would definitely, the higher net worth individual you are, the more disposable income you have, and the more I encourage you to go and get insurance. But if you're a lower income individual, think about it. You may still want to carry it, but you got to really, do the cost versus benefit analysis for that. Now, keep in mind, a lot of places will require you to carry insurance, or at least attest to the fact that you have the ability to cover some sort of losses. Like hospital privileges will often require that. Managed care provider contracts will also require that. So do your cost versus benefit analysis. If you ever happen to get into a lawsuit and you end up settling that lawsuit with your name in it, do keep in mind every time you settle a lawsuit with your name in it, it is reported to the NPDB, which is the National Practitioner Data Bank, and that's a big ding against your license. So if you ever end up getting into a situation where you have a lawsuit, you may want to settle that lawsuit by getting your name out of it first so that you get dropped as a named party, and then you can let others settle out that lawsuit without your name in it. So you've got to get out of it before it's settled out. Otherwise, your name goes into the actual settlement and it gets reported to the NPDB. So how to begin your asset protection planning journey. This is how you do it. You basically start off with creating a list of what are your risks, what are your assets, what are your liabilities, your income sources, who are your family members, and that the obligations that you have outstanding, and what do you really need to maintain and leave behind. And you compare that to the liabilities and expenses that you have and what's coming on the horizon. Once you have actually created a list of that, what you do is you compare it to the right side of this chart, where you first of all make sure that everything, you're maximizing your statutory protection. You're using corporations, you're using trusts, and you're using your stacking techniques to make it all happen. And you may want to consider creating a personal lending company where it is actually a loan amount that one of your holding companies lends out to the other company. Should that company ever come into attack, you always have the ability to pull back the money into your holding company or your lending company. Now, the other things that we could talk about is offshore corporations and trusts and offshore accounts. Just for chuckle's sake, there's certain tax havens out there. There's certain issues of confidentiality. People like to hide money. Again, my first preference is keep the money domestically. You know what's going on. You know what the rules are. But a lot of people will go to the Cayman Islands, Switzerland, Belize, Singapore, and a few other countries. It used to be the St. Kitts and a few other islands years ago, but I usually don't deal with people like that. I used to have really, anyway, trying individuals that needed offshore protections, and they needed to make sure that their money was safe. So I used to help them, but anyway, you probably are not at that level. Most of us are not, and if you are, then you need probably more than what I can offer you. So when you do start planning this, you want to get your tax accountant and your asset protection planning attorney into the same room. Make sure that they're talking to each other, that they're considering not only the how to protect the assets, but how to minimize the taxation of those assets. So you may want to review whatever plan you eventually do put together, whatever corporations, your trusts, you want to review that plan every couple of years, if not every year. And especially if you have a major shift in assets or liability, that's also a good time to go and review this whole setup that I'm showing you on this slide all over again. So with that said, that is the conclusion of my webinar. And if you guys have any questions that you want to go on the recording for, you can ask those questions now. Otherwise, we're going to shut it off in about 5 seconds if nobody has a question. And then you can ask your questions off the screen.
Yeah, that's great, Ben. I think I'm going to shut the recording off and see if there are any questions, and appreciate it. And we'll see you. But Ben, we'll finish up afterwards. But I'm going to shut the recording off now.